Hi there. Thanks for tuning into the Canadian Constitution Foundation's Freedom Update. Today was the 7th day of hearings in the Public Order Emergency Commission, also known as the Rouleau Commission. This is the legally required public inquiry into the federal government's first ever invocation of the Emergencies Act, which was done in response to the 2022 Freedom Convoy. The Commission is examining and assessing the basis for the government's decision to declare an emergency. In this video, I'm going to give you a quick summary of some of the things that really stood out to me in day 7 of these historic hearings. During today's hearing, there were 2 witnesses, OPP Officer Craig Abrams and OPP Chief Superintendent Carson Pardy. But in this video, I'm only going to be summarizing the evidence from Chief Superintendent Pardy because Craig Abrams' testimony was split between yesterday and today, and I actually missed his testimony yesterday. But don't worry, our team of lawyers all watched it. I also have an update about the book project that I told you guys about a few days ago. The book is now available and we're giving away copies to our supporters totally for free. So I've linked to where you can get it up there and also in the description below. And I'm going to tell you more about the book at the end of this video. Okay, let's get into what happened today. If you're new here, welcome. My name is Christine and I'm the litigation director with the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing cases, as well as a series of videos that summarize what happens in the Rouleau Commission hearings. If that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, remember, my videos are not legal advice. If you have your own legal question or problem, please consult your own lawyer. Before getting into exactly what happened today in day 7, remember that this is just my summary of some of the key parts of a full day of hearings that really stood out to me as especially interesting. This is not a complete summary of everything that happened. And also keep in mind that unless I tell you otherwise, this is just my summary of the evidence. It's not necessarily my opinion of the evidence. Even though at some points I will give you my opinion, I'm always going to tell you when I'm doing that and that it is my opinion. This is also just my best recollection of what happened based on my observations and notes. If you want to know every single detail of what happened, you can watch the hearings on the Commission's website. They are streamed live and the previous recordings are also posted on the Commission website. Okay, let's get into the evidence from OPP Chief Superintendent Carson Pardy. So Pardy was the former major critical event commander for the OPP. He's now retired, and he led the OPP team that went to Ottawa for the protests. He testified that the mandate for his group was to provide Ottawa police with support. It was not to take over the operation. He said the OPP was there with an intent to integrate commands because there was a need for resources and that the situation was beyond what Ottawa police could do by themselves. Pardy testified that upon arrival, he was kind of like, what happened to you guys in Ottawa? He said that they used to be a first-class organization when dealing with protests and major large-scale events, but that things were not going well. He testified about his concern that there wasn't a plan from Ottawa police. The Ottawa police were asking for a lot of resources, but with no concrete plan for how they'd be used. He said there was a lot of dysfunction, as well as a loss of faith in the police from the public. He also testified that Ottawa police had a lawyer who sat through operational discussions, which he thought was, to quote him, bizarre, and that he'd never seen that before. He testified that the lawyer seemed tantamount to an approver of an operational plan, which he said was concerning because this was police operations. Chief Superintendent Pardy was asked by counsel for the commission how the police could make a plan when they didn't know how many resources they had. Kind of this cart before the horse question. But Chief Superintendent Pardy replied, this is a loaded question. The fact is you need to be able to articulate the logistics, briefings, and plans of what officers are going to be doing. You always need a plan. And that staffing is an issue with Ottawa police, but that is nothing new. It is an issue with every police force. A reasonable commander coming in who is going to be asked for resources, but that commander is going to be pulling on his own resources that are used in other communities. And a reasonable commander is only going to pull those resources, those officers, when they're actually needed. Not so they can come and sit around and wait for a plan to be developed. A plan can be in concept, but it can't just be, hey, I need a number. You need to show what these officers are going to be doing when they get there, when they arrive in Ottawa, exactly what they're going to be doing, where they'll be staying, how they're going to be fed, all of this important stuff. And he said none of that was in place in Ottawa. Pardy was asked if the Ottawa Police's plan development was intelligence-led. This had come up earlier in testimony from OPP Superintendent Morris. Chief Superintendent Pardy confirmed no. He testified that the Ottawa Police were not looking at the broader event and intelligence to think about how they could dismantle the protest peacefully. He also testified that there was no integrated plan approved until February 13th. Counsel for the commission then turned to the question that I am most interested in, and that is the Emergencies Act. Pardy was asked if the final plan of February 17th contemplated any of the powers or measures that were made available under the Emergencies Act. Pardy confirmed that it did. Like in every plan, police consider their people, their officers, and he said in this case, they made sure their officers were aware of the Emergencies Act and to use it, and they were instructed to use it to the best of their ability. Pardy was asked if the police in Ottawa needed the Emergencies Act to tow vehicles. He said no. Police tow vehicles every single day. If a vehicle is used in an offense or if it's evidence, they have authority to tow. And there's also provincial legislation on towing and removing commercial vehicle registrations. They did not need the Emergencies Act to do this towing. Pardy was asked about an interview that he had given to the commission before this hearing. And in that interview, he said police would have managed to put an end to the protests without the Emergencies Act. And they would have done it on the same timeline with the same plan that they developed before the Emergencies Act was invoked. Pardy confirmed in his testimony that the Emergencies Act didn't change anything. He said it helped, and he wasn't going to say that it wasn't useful. It provided them, he said, with some towing and perimeter authorities, but he said they could have done that anyway. He was then asked directly, in his view, was the Emergencies Act necessary to end the protests in Ottawa? Pardy replied that this, again, is a loaded question. He would only say that Parliament gave the police access to this legislation and they incorporated it into their plan. He also confirmed that there was a policing solution to the protests. Recall that Ottawa Police Chief Slowly had made some statements that there was no policing solution to the protests. Well, Chief Superintendent Pardy said yes, there was a policing solution, and that in fact that ultimately they reached that solution, and that they would have reached that solution even with the use of the Emergencies Act and on the same timeline. Next, the commission moved on to cross-examinations. The Government of Canada asked Pardy if the integrated plan was only able to obtain heavy vehicle tows because of the Emergencies Act. Recall there was some evidence yesterday from Ferguson of the OPP. The tow trucks were actually on their way before the Emergencies Act was invoked. Pardy said it was not true that they only had access to heavy vehicle tow trucks because of the Emergencies Act. He testified they had 34 rigs lined up before the Emergencies Act was invoked. And he said that there were some who were reluctant because of what he called liability issues and that the Emergencies Act gave them support on that. The Government of Canada lawyer then brought up some emails which were dated February 16th, so this is after the Emergencies Act was invoked, that said that the police only had 10 heavy vehicle tow trucks and that the police wanted to tell the towing companies that the Emergencies Act was going to indemnify those companies of any damage. Pardy responded to this by saying his understanding was a significant number of tow trucks were available before the Emergencies Act was invoked, but that the Emergencies Act helped because of this liability concern from some holdouts. This came up again on cross-examination by the lawyer for the Democracy Fund. The Democracy Fund lawyer showed Pardy an email from 4 days earlier than the one presented by the Government of Canada. So this email was on February 12th. That's before the Emergencies Act was invoked. And in that email, it said that there were 34 heavy vehicle tow trucks lined up. Pardy was asked if it was possible that the number of trucks decreased after the invocation of the Emergencies Act. Pardy replied, yes, it is possible that the invocation of the Emergencies Act caused some towing companies to become more reluctant or to put more restrictions like indemnities into their agreement to let the OPP use trucks, but he said he does not think that is what happened. So he was asked what did happen? What material thing could have caused this reduction in the number of companies agreeing to let the OPP use their trucks? He said that this question might be better posed to someone else, but what he knew was that getting tow trucks was always contentious from the start. Chief Superintendent Pardy also testified that the profile of the protesters was not like anything he had ever seen. He said it included grandmothers, retired police, including officers who had retired, who used to work for him. It included retired military, it included children. He said there were still concerns with what he called, to quote, extremism, but that for this they relied on intelligence. There were also some interesting questions from the government of Saskatchewan and the government of Alberta. Now recall that these two governments have opposed the federal government's use of the Emergencies Act. The lawyer for Saskatchewan asked if the Emergencies Act was needed to set up the integrated command structure, and Pardy replied, no, definitely not. It was not needed for that. Pardy also confirmed that the police didn't need the Emergencies Act to come up with an operational plan. He was also asked about the operational plan he signed off on February 12th, and he confirmed that he was confident that this February 12th plan, recall before the Emergencies Act was invoked, that it could be used to end the protests, and that plan did not contemplate any powers under the Emergencies Act. He was asked if he thought such powers, like the powers under the Emergencies Act, were necessary, wouldn't he have told somebody? And he said yes, but they felt that they had what they needed with existing powers to dismantle the protests. The lawyer for Alberta asked Pardy about the tow trucks again. This was a big issue today. And Pardy confirmed that some tow trucks were reluctant because of these, to quote, liability issues. For example, people were worried that their tow trucks could be damaged. He said that there were trucks willing to do it, they just wanted a liability assurance. The lawyer for Alberta asked Pardy, aren't there tools under the Emergencies Act of Ontario that could protect these trucks from liability? And Pardy confirmed yes. The lawyer for Alberta also asked Pardy, does that Ontario Emergency Act allow for compensation from the provincial government for people who are enforcing orders under that Emergency Act? And Pardy said that he doesn't know the details of that. This is all important because, remember, the Federal Emergencies Act can only be used if there are no other legal tools available. So the Alberta lawyer is trying to get at this question by citing other laws that could have been used to solve these concerns around indemnification and liability and compensation for tow truck drivers. In other words, trying to get at this question of whether it was only the Emergencies Act that could be used to give these liability assurances. And if those powers are available under the Ontario emergencies legislation, well, then the Emergencies Act was not necessary to give those assurances. Today, the commissioner himself, Commissioner Rouleau, also asked some questions of Mr. Pardy. He asked Pardy about the difference between calling this a protest and an occupation, because those terms have both been used by all of the witnesses. And Pardy replied by saying that these are interchangeable for him, but this was definitely an occupation as well. Commissioner Rouleau also asked if there was any thought about the charter rights of people who wanted to protest in some other way in some other place. The charter rights of protesters was part of the mission statement of the operation, so that's how this came up. Pardy replied by saying that if you're in the red zone protesting, it's breaking the law, and it's been deemed illegal. At that point, there was an injunction in place, there was criminal mischief taking place, and the protest had been deemed unlawful, and people protesting in that area needed to leave. If they wanted to move to a different location, Pardy testified that could have been facilitated by the Ottawa Police Services negotiating team, that's the PLT team. And he said if someone said, we have a right to protest, that the police would have said, yes, you do, but not here. The commissioner also asked, was there any part of the plan that provided for this aspect, allowing the protesters to continue their protests somewhere else? Pardy replied, at that point, no, their negotiations with the protesters had now become futile. The commissioner asked Pardy if he was aware of people criticizing in the media or otherwise the operation because these people just wanted to protest. And Pardy replied that he was actually avoiding the media at that time, but he didn't doubt that there was criticism. He added that there were a lot of good people who just wanted their voices heard, and mentioned again that profile of protesters was very unique. Recall his description I gave earlier of grandmas and kids and retired police. But he added that these individuals existed with other people where there was more of a threat of violence. The commissioner asked Pardy if he felt like the plan was adequate in allowing for people to continue the protests in other ways. And Pardy replied that by the end, this was the only option that the police were left with, having exhausted everything. Okay, that's it for today. I hope you enjoyed this summary and found it to be informative. So next week, I'm actually not going to be posting daily video summaries. I have too much other work to balance and it's really exhausting, but I'm going to try to continue to do maybe weekly summaries or summarize a few days at once. One of the things I've been so busy with is the release of my new book. I am so excited to bring you this book. It's about how Canada's federal structure can be used to protect liberty and constrain government overreach. The book is edited by me, and I did the introduction along with our executive director, Joanna Barron, and the chapters of the book are authored by some of Canada's leading scholars and legal practitioners who have generously donated their time and expertise to contribute to this project. Typically when Canadians think about how the courts and how laws can enhance liberty, they think about the Charter of Rights and Freedoms. And of course, the Charter is an incredibly important part of our Constitution that guarantees our fundamental freedoms. But it may surprise many Canadians to learn that the federal structure laid out in the Constitution Act 1867, the division of powers, and the decisions related to federalism can also constrain government action and that in that way promote freedom. This book looks at how the division of powers can be used to mitigate against the centralizing power of the federal government. Of course, an unchecked, strong federal power risks unduly treading into the jurisdiction of the province, and this can be to the detriment of citizens of less populous or influential provinces. The book also looks at how the division of powers can likewise prevent the provinces from imposing their own restrictions on liberty when those restrictions are in the jurisdiction of the federal government. So in other words, all levels of government can overreach and fetter freedom, and the federal structure can actually be used to prevent this when that fettering is outside of the jurisdiction of that level of government. I really hope that this book will expand your awareness about how our Constitution can protect you from government overreach, and that the courts will continue to hear cases on federalism and decide these cases using a coherent federalism analysis that protects rather than erodes liberty. You can sign up for a free copy at the ccf.ca/freedom through federalism. And if you do sign up, please leave a comment below and let me know what you think. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.